Well, good morning and thank you so much for joining us today. This is the last in our webinar series as a part of National Farm Health and Safety Week. Today we are going to talk about sexual harassment prevention. We also want to thank our partner and sponsor, the wonderful company, for providing support for all the content this week. We appreciate them very much. My name is Natalie Gupton, and I will be your speaker today. I am the Director of Business Services and Industry Relations for AgSafe. AgSafe is headquartered out of Modesto, California, and I am all the way on the other side of the country here in Louisville, Kentucky. So we do work nationally. I encourage you to follow us on social media if you haven't. We are providing recordings of the week's webinars on Facebook and links on Twitter as well. So check us out at AgSafe Online, and encourage you to visit our website. We've got lots of resources and information out there for you to access and check it out. Again, that's agsafe.org, and would love to have you there. Before we get started, I would give you just a moment to review our disclaimer. So we are only going to be together a short time today, so we're just going to have a quick overview on the topic. Just want to remind our friends in California, this does not fulfill any trainer requirements. We have a much deeper, more in-depth presentation to be in compliance in the state of California. So this is just a refresher and a reminder for you. In our objectives, today we're going to talk about the laws and regulations about harassment in the workplace, definition of sexual harassment, agency oversight, and some guidance for employers. So whether or not you are a large business and agriculture organization, or you just employ a couple people, sexual harassment prevention is extremely important and a conversation that you need to have with your people. And the first step in prevention is having conversations, talking about it, and recognizing and describing what it is. So I don't think it's any secret. We know it's against the law, but from the federal standpoint, it's listed in Title VII of the Civil Rights Act of 1964. So this law makes it illegal to discriminate against anyone on the basis of race, color, religion, national origin, or sex. Sexual harassment is considered a form of discrimination and is illegal. And state laws, depending on what state you're in, there are many more things that fall into their specific sexual harassment prevention laws. Many states require public employees to undergo training, and some even require any employer in the private sector to undergo some type of training. Some go as far as if you're a supervisor or just a regular employee. So being very mindful of that. We know California has very state-specific laws. I know New York does as well. So if you're outside of those two states, do a double check to make sure that you're compliant, and if you are required to do any type of sexual harassment prevention training by law. If not, kudos to you for joining me today, because you are you're being mindful of your employees' safety and want to do what is right, and having some form of training and talking about sexual harassment prevention is important. So there are two types of harassment. First, there's the quid pro quo, which means a favor or advantage granted or expected in return for something. So often you think of in some sexual harassment cases that if a manager hiring individual is talking to a hiree in an interview, and they're like, hey, if you don't have sex with me, I'm not going to give you a job. That is a quid pro quo. You do this, I give you a job. Or if you think of maybe a supervisor in the field saying, you know, you need to do X, Y, and Z, or I'm not going to recommend you for a raise or a promotion. So often, that's where lots of types of sexual harassment arise, is in those quid pro quo types exchanges. The second is a hostile work environment. And so this boils down to essentially bullying and that harassment aspect of creating a hostile work environment. With that, it's essentially what a reasonable person would deem hostile. It's when somebody approaches with malice and intent to sabotage. It certainly can create a hostile work environment and make people uncomfortable to come to work. And that also falls into sexual harassment and discrimination. You know, when you are having a conversation, when you're conducting a training, you need to talk about what are some examples of what sexual harassment could be. So the example I gave about, you know, having to sleep with somebody to get a job is an obvious one. But thinking about different types of conduct, you know, you've got visual conduct, which means leering or making a sexual gesture could be deemed sexual harassment. You know, verbal conduct, I mean, using derogatory comments, slurs, and of course jokes. Jokes, you get into that gray area and can certainly be offensive. Verbal abuse, and that's, you know, language of sexual nature, graphic verbal commentaries about an individual's body, sexually degrading words used to describe an individual are examples of what verbal abuse would be. And then physical contact. Of course, we often do think of most cases of sexual harassment as somebody touching another person, but it can also be that impeding or blocking people's movements. That again falls into that category of that hostile work environment. Many of these are because you're making an individual uncomfortable, you're making them hard to work, and certainly all examples of what can create a hostile work environment. All right, so Equal Opportunity Commission, the EEOC. So how do these regulatory agencies define sexual harassment? So it is the unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when, and you have 3 instances here within the EEOC definition. That submission to conduct is either made explicitly or implicitly as a term of an employment. So going back to that quid pro quo example, if you don't do this, I'm not going to give you this. Submission to or rejection of conduct is used as a basis for an employment decision. So certainly that quid pro quo example again. And then such conduct has the purpose of interfering with work performance or creates a hostile work environment. So these are the actual definitions that support these two types of sexual harassment from that regulatory agency. And again, it's important to remember that harassment does not have to be of sexual nature. However, it can include offensive remarks about a person's sex. So again, this training and prevention in the field, letting your employees know that you can't make fun of somebody because they're a woman, or if they identify in any other way. Very important to consider that we need to talk about these things with them, that they understand that sexual harassment isn't just sexual in nature, but that hostile work environment comes into play for a lot of cases as well. Both victims of both victim and harasser can be either a man or a woman, and also the victim can be of the same sex. Like, thinking of that hostile work environment, it could be peer-to-peer, woman-to-woman in a harassment situation. So keeping that in mind as well. And then, although the law doesn't prohibit simple teasing, offhand comments, or isolated incidences that are not very serious, harassment is illegal, and those things can pile up and amount to something serious, more serious over time. So when does harassment violate the federal law? So harassment violates federal law if it involves discriminatory treatment based on race, color, sex, so again, with or without that sexual conduct, religion, national origin, age, disability, genetic information, or because the employee opposed job discrimination or participated in an investigation or complaint proceedings with the EEOC. And federal law does not prohibit simple teasing, offhand commands, or isolated incidences. The conduct must be sufficiently frequent or severe to create a hostile work environment or result in tangible employment action, such as hiring, firing, promotion, or demotion. So taking these things into consideration, I pulled this directly from the EEOC website. So knowing when somebody crosses the line. Going back to that teasing, jokes, derogatory statements, cussing is not harassment. Calling somebody sweetie, though not recommended, again, isn't harassment. However, when it becomes, again, frequent or severe, so when you're not treating everyone in your workplace, not treating everyone that works for you or even visits your facility. So if you think of agritourism, when you're not treating everyone equally and being fair and consistent with your language, but also your policies, then you're getting into some gray areas and can cross that line into harassment. And talking through this as a part of your prevention steps with your employees is knowing that when it becomes pervasive is when it's a problem. So what does the EEOC do? So they play a role in the complaint process. It has the right to investigate charges of discrimination against employers. In 2017, the EEOC received approximately 23,000 complaints of sexual harassment in workplaces. If the commission discovers discrimination has occurred, they will try to settle the charge. So they try to do this without the courts and litigation. And if they're unsuccessful, they have the authority to file a lawsuit if it deems necessary. And in 2017, the total monetary benefits that were paid were approximately $125 million. So that's outside of litigation. Those are settlements and corrective payments to victims. So $125 million were a result of those 23,000 complaints that the EEOC received. All right, so employer guidance. So you need to provide all employees with sexual harassment prevention training, and that can be in person or online. Whether or not you're a large organization, you've got to provide some type of training. I've had discussions with friends that work in different industries, and hearing what kind of goes on behind the scenes, sometimes it's like, oh my gosh, they have no idea that their actions could be considered sexual harassment, even though they may be doing it innocently on the surface, but it can boil down to sexual harassment. So providing training is essential to protect your employees, but also protect you as an employer. And when you do training, you've got to make it relevant for the people that you're speaking with. You know, the words that I'm using, I'm talking about business, workplace, so on and so forth. And you've got to make it less formal in a way that they can understand and internalize the information. So you need to use examples of a farm work environment that your employees can wrap their head around, knowing that unfairly applying a no tardy rule to one person and not to another could be an example that you can use, that you have a crew leader who is punishing one individual on their team because they show up on a daily basis 5-10 minutes late. However, there's another person on the crew who shows up perpetually late, even 15-20 minutes late, and is never spoken to, is never written up. And then on top of that, you have that supervisor call them out frequently for doing poor work, calling them slow, calling them short, and just having pervasive actions against one particular employee and ignoring bad behavior by others is an example that you can use in training, that can be discrimination and harassment. Next, provide all employees with your company anti-harassment policy. So, you know, company, farm, business, you need to have some type of policy in place. You know, if you're small and teeny and have a couple employees, having a statement that you prohibit sexual harassment or discrimination of any kind on your farm, and if anything ensues, you will take action. Having a simple statement that is could be enough for you, and it just brings it to the forefront and lets people know that you do not tolerate any type of harassment or discrimination, and it's important to you that people recognize that. But within that policy and within your organization, need to define harassment, and work smarter, not harder. Go directly to the EEOC website and get the definition there. You don't have to think too hard about it. Certainly that is sufficient, but define it for your employees that they know and understand what is considered harassment. You need to have a thorough complaint process, including multiple paths to complain about harassment, even outside the chain of command, which is so very important. You know, if you are a large entity, have multiple employees, you have multiple supervisors and crew leaders, then yes, you have to have multiple avenues for a person to file a complaint. Hopefully you will never need it, but you need to have one in place that an employee knows that if they experience harassment or discrimination of any sort, that they can go to, you know, any individual that you name to make a complaint. You know, if it is their direct supervisor, which unfortunately often that person in that position and quote unquote power is often that harasser. So you can't always make that supervisor the one person that that individual can go to. You need to let them know that they can go around their supervisor and go somewhere else. Talking through with your employees, if you're small, and letting them know, you can tell, you know, you, or you can have your spouse be an option as well, or let them know that, you know, if you experience anything, even out in you know, the community, because they're interacting only with 3 or 4 people each day on your farm, but they could experience something while they're running an errand, while they're picking up feed at the mill, and have them know that you do not tolerate that and you will address it, and that they have to let you know when something does happen. Encouraging employees to report harassment before it becomes pervasive. Like I just said, you know, even if it's somebody out in the community, that employee is your responsibility. And so assisting them and helping them through something like that is important. And if it becomes a pervasive issue, you certainly can take some action with a business. But if employees don't tell you that things are occurring, then you can't do anything about it. And emphasizing that with all of your workers is necessary. And sometimes they may need to say something, and it's not a formal sexual harassment complaint, but reporting something that is occurring, then you can address it quickly before it becomes a bigger problem. You need to provide protections against retaliation. So not as much of a problem for smaller entities, but when you have so many people employed for you or under you, you can have that possibility of retaliation and you not know it. And letting your managers and supervisors understand truly what retaliation is and how serious it is. It has lots and lots of liability and issues related to it. And letting them know that retaliation against an employee after he or she has filed a complaint about harassment or participated in an investigation is unlawful and can lead to serious consequences. And you know, I think we all probably know what retaliation means, but it's when you intend, because that person participated in something or filed a complaint, then you take action because of that. And that's, you know, you fire them, you write them up, you demote them. Any of those things can be considered retaliation if it's directly related to their participation in a complaint or an investigation. And then also within your policy, you need to include consequences for violation of that policy. You know, it could be a tiered approach. for that, having a disciplinary measures, but also ultimately, depending on the severity, it could mean termination for an employee. So those are some very key things you need to consider in having an anti-harassment policy for your organization. And again, talking about, smaller entities, few employees, and having something simple and written out, a couple paragraphs, a couple bullet points may be enough to get the message across, and just having it on paper and available speaks volumes. Okay, so this is a great resource, especially if you're a small employer and just want to wrap around what your responsibilities are as an employer as it relates to sexual harassment prevention. This is an older screenshot, but the questions are exactly the same. But the frequently asked questions provided by the EEOC, the link at the bottom will take you there. And of course, you can search. Google takes you everywhere these days. But search for that, and it's very straightforward and easy to navigate. Talking about questions: when does harassment violate federal law? When is an employer legally responsible for harassment by a supervisor? And who qualifies as a supervisor for purposes of employer's liability? Discussing what tangible employment action is. And then a little bit more information about important elements for a complaint process, and all these things that are great to consider, and we've briefly touching on during this presentation. So check that website out. Most government agencies, though we get don't have warm and fuzzy feelings about some of these agencies sometimes. Don't let them scare you. They have lots of resources and outreach programs available to you, and they want to assist you in doing the right things and help you be compliant. So they have great outreach arms, and I encourage you to take advantage of those and the resources that they have available. And I'm not sure why there's, okay, it was delayed. I didn't have any actions on the other slides. So important thing with sexual harassment prevention and discussing with your employees is intent versus impact. A lot of instances boil down to this. Intent is not relevant in determining whether or not a behavior is sexual harassment. Impact of the behavior is what matters. And then regardless of the intent, the behavior will be judged on its impact. So in some instances, you've really got to discuss that you've got to think before you act, because some cases you do not intend to offend or hurt or discriminate someone, but ultimately it's that impact, it's the receiving end. How did that individual take that? How did that individual receive that information? Often jokes are the culprit here with intent versus impact. So always being mindful of that and discussing that with employees. And talk about appropriate workplace behavior. And ultimately, this assists with the culture of your farm and your operation, and laying out your expectations of what you need an employee to do and how they're supposed to act at your place of business. You can talk about respect and appreciating the people that are around you, and to think before acting, again, going back to that intent versus impact. Talk about exercising common courtesy, and think of other people and how they might be feeling, and being sensitive to diverse perspectives. And think twice before making a joke, and any joke. And then have a code of conduct. Having what you expect explained and laid out to your employees. This is something that you want to discuss at the time of hire, and getting them acquainted with your organization. You want to set these expectations early, and hopefully this appropriate workplace behavior expectations will assist in the prevention of any type of harassment or discrimination. So in conclusion, sexual harassment in the workplace / farm, your farm is certainly a workplace, is an ever increasing issue. Employers need to stay proactive, provide policies and training to all employees, and ensure that they have processes in place to promptly respond to a complaint and provide a workplace that is free of harassment. So I thank you for joining me today. Please post any questions that you may have in the chat box. I want to give a huge thank you to the wonderful company for their support of National Farm and National Farm Health and Safety Week with AgSafe. We appreciate their generous support. Encourage you to check out all of their wonderful products, no pun intended. Yeah, this is an overview of all the webinars that we posted this week. Those recordings are available on our YouTube page and on our social media site. So please access those if you missed any. And with that, I want to provide a sincere thank you for those that joined me today and all week. Your proactiveness and attention to safety is so important and much appreciated. So thank you so much, and I hope you have a wonderful and safe day.